Hello, everyone. Welcome in. In this video, we will be discussing the newest lawsuit surrounding Team Trevizo, this time filed on behalf of Alexee Trevizo against Artesia and the hospital. Now, the city of Artesia is standing for the police. This is a civil rights lawsuit against the police and the hospital. First and foremost, we must note that this is Team Trevizo continuing on with the idea that the hospital and police work together with some sort of agency relationship in regard to what happened at the hospital that night after baby Alex was found. Now, if you've seen this channel, if you've followed this case legally for any period of time, you may know that that argument has some very distinct and exact criteria to be met for the hospital staff to turn into law enforcement. Now, we are going to be discussing a case that I just recently found that I think is going to be a guiding light for the Supreme Court as they make this decision. And I think will lay everything out for us plain and clear. But before that, let me remind you of the two critical factors for a private actor, such as a doctor, to turn into a government agent, such as working for the police. Number one, it's whether the government agent knew of or acquiesced in the intrusive conduct. And number two, whether the private party's conduct was done with the purpose of assisting law enforcement or to further its own ends. Now, if you have followed any videos on this channel that have discussed this agency argument, you've heard me explain both of those factors and explain why I do not think that they are met in the Alexee Trevizo case. Number one, the doctor asked if the police would like to be present for the conversation that she was about to have with Alexee Trevizo. That means that the government didn't acquiesce any conduct. This was on the doctor's behalf. And number two, the doctor definitely had their own ends to further, even to wait to discuss this with the police present with Alexee Trevizo, meaning that now the doctor has mandatory reporting laws enacted, has the legal liability of themselves and the hospital to be thinking about. They have to worry that anyone who does speak with Alexee Trevizo before the police are present may get more information, more evidence that they would then have to be tied up with law enforcement further. It was best, and it happened perfectly for the doctor to try and separate these, two instances. The telling Alexee Trevizo that they found the baby, which is furthering their own medical ends because the doctor basically begged Alexee Trevizo to accept the medical care and transfer. And then number two, the doctor wasn't trying to interrogate Alexee Trevizo or ask Alexee any questions other than if she was willing to be transferred. This is not an investigation, an attempt to elicit an incriminating statement or to, fish for evidence. This was simply the doctor having to work how they had to work. And it was very lucky that the doctor got to wait for the police officers to be present because they showed up and entered the room within 10 minutes of baby Alex being found and pronounced dead. That is a quick police response time to this incident, and it didn't make Alexee Trevizo's care wait or be hindered in any way. We have to say all of this because these are the claims that the defense is going to be making when arguing that the police and the doctor violated Alexee's civil rights. Now, we are still waiting on a decision to come back from the Supreme Court about the evidence in this case, which will very much clear up all of these issues and say once and for all if Alexee Trevizo had any semblance of her rights violated or if everything in this case is up to par and was done without the intent to violate Alexee's constitutional rights. With that, we are going to be reading a decision from the Court of Appeals in the Seventh Circuit that deals with an issue very similar to this, but the police and doctor involvement is actually so interesting and so intertwined that when the Supreme Court actually makes their decision that the doctor wasn't acting as an agent of the police in this case, we would have to seriously question how the Supreme Court can ever find that the doctor was acting as an agent of the police in Alexee Trevizo's case. This is important because the Supreme Court's decision will either make or break any of the civil cases that have been launched against the hospital and or the police, namely the wrongful death case for baby Alex that has been launched against the hospital and Dr. Vasquez, and now this civil lawsuit against the police and hospital for Alexee's civil rights. The wrongful death lawsuit against the hospital is already stayed pending the Supreme Court's decision. So one court and one judge has already decided that the ultimate decision coming from the Supreme Court will be such a guiding light for these further cases that they can't even do anything with it right now. And so this civil case being brought here, basically in the first week of January 2026 is very telling to me, because the statute of limitations would run out on this claim for Alexee Trevizo at the end of this month. It would run out on January 26th to 27th of 2026, 3 years from the date of the incident when you can make the claim. And so why would Team Trevizo be bringing this lawsuit, early January, just 2 weeks before the deadline for the statute of limitations? Possibly because they've been trying to wait out the clock as well, and they still don't have a decision from the Supreme Court. So they do need to preserve this issue, but they are essentially shooting in the dark. They are straight out of options. They are having to bring this lawsuit so that they don't lose their chance in the off chance that the Supreme Court comes back in their favor. But the fact that they just brought it now in hopes to preserve the issue, not meaningfully, immediately, how they did with the wrongful death lawsuit against baby Alex, to me, that says this is a secondary thought. This is a reactionary lawsuit to the fact that this has not been decided by the Supreme Court. And it's basically just to shoot a shot in the dark and hope it comes out okay in the end. Otherwise, it's a waste of everyone's time, money, and efforts, because the Supreme Court could very well come back and say that all of this evidence gathered was done by the book and did not violate Alexee's constitutional rights. All right, so with that, let's look at this decision from the Court of Appeals and see what we think about this situation, their decision, and the comparison to the actions of the doctor and the police in Alexee Trevizo's case. So early in the morning on January 23rd, 2022, Mr. Hudson walked into a medical center seeking emergency treatment for a gunshot wound. While an officer investigating the shooting stood outside Hudson's hospital room, medical staff discovered Hudson was concealing, quote, something plastic in his mouth. Medical staff spent nearly 20 minutes admonishing Hudson to spit out the item before he finally complied, revealing a device used to convert a firearm into a fully automatic weapon. Hudson was subsequently indicted and moved to suppress the device, arguing that the medical staff acted as government agents in conducting a warrantless search. The district court denied the motion. Hudson pleaded guilty, but reserved the right to appeal the denial of the motion to suppress. We now affirm. Background. A shooting took place outside a bar in Bloomington, Illinois in the early morning of January 23rd, 2022. Members of the Bloomington Police Department responding to the shooting reported that a vehicle left the scene with a shooting victim in the passenger seat. Bloomington police officer Benjamin Smith pursued the vehicle. Smith's body-worn camera recorded the ensuing events. Smith arrived at the parking lot in the medical center and observed Mr. Hudson exit the front passenger seat of the vehicle. In response to Smith's directive to put his hands up, Hudson repeatedly announced that he had been shot in his butt. Smith briefly frisked Hudson and then escorted him into the emergency room. Medical staff immediately brought Hudson to a treatment room. Smith followed them, asking questions about the incident as medical staff began assessing Hudson's wound. As more staff entered the room, Smith took a few steps away from Hudson. After Smith informed a doctor that Hudson was not in custody, the doctor asked Smith to leave, stating, "I just don't want PD around." Smith responded that he was, quote, not going to let Hudson out of his sight until we know who's who in this scenario. After a short pause, he added, "I won't interfere. I will stay out of your way completely, sir. This is your show. I will work around you." The doctor walked away and began assisting Hudson without further comment. About a minute later, Smith left the room, standing quietly in the hallway directly outside of the room's open door. When the doctor exited Hudson's room about 6 minutes later, Smith asked, "Can we avoid washing his hands for the time being so that we can do a gunshot residue kit?" The doctor stated that he would not wash Hudson's hands because, quote, "that's not part of what he routinely does for folks." Smith stated that he would wait to conduct the residue kit until it was, quote, "convenient for the doctor," and the doctor returned to Hudson's room. Officer Brandon Fink then arrived and joined Smith in the hallway. Shortly thereafter, the officers overheard medical staff stating that Hudson had something in his mouth. Numerous staff members directed Hudson to spit out the item, but Hudson refused. Overhearing the commotion, Smith asked a nearby nurse if Hudson had something in his mouth, and the nurse confirmed that he had, quote, "something plastic in his mouth." Smith then stepped inside the examination room, announcing, quote, "They're trying not to kill you, okay? Just spit it out, okay? I'm not trying to charge you with drugs. Just spit it out." Medical staff did not acknowledge Smith's statements and continued admonishing Hudson to spit out the item. Presuming that Hudson was concealing drugs in his mouth, the doctor warned him that the drugs could get him, quote, "real sick," and that they could also prevent or obstruct treatment if he needed to be intubated. Smith then piped up again, remarking, "They aren't going to treat you, dude." In response, the doctor immediately walked towards Smith, shaking his hands and stating, "Please don't. I don't want to." The doctor then closed the curtain, blocking Smith's view of Hudson and the treatment room. So that I just want to make this little part very clear before we continue on. The hospital staff are trying to get this guy to spit whatever's in his mouth out, and the cops trying to pipe up and convince the guy also to spit out whatever's in his mouth. But the doctor probably is thinking and seems exasperated from how I read it. He's like, this isn't going to help. No one wants to spit out something possibly illegal in front of the police officers. So he's like, get out of my face. Let me do my job. And no matter what it is that's in this guy's mouth, if he swallows it, it is going to make the doctor's job harder. So the doctor's like, get out of here. Now we can continue. Smith returned to the hallway with Fink as medical staff continued their unsuccessful efforts to persuade Hudson to spit out the item. One medical staff member told Hudson that his throat could be occluded by the object if a breathing tube became necessary. Another stated, "They're not going to let you leave. The cops are here and they're not going to let you out of here with that in your mouth." Approximately 10 minutes after first discovering the item in Hudson's mouth, the exasperated doctor again approached Smith. "Doctor, he's got something in his mouth that he's not getting out of his mouth, and I don't want it to end up swallowed because it's evidence. He's going to end up sick." Smith, "Absolutely, absolutely. We're not trying to charge him with anything." Doctor, No. I told him everything in him is part of a crime scene, because he was shot with a weapon. And he's not cooperating at this point. So if you have ways to convince him, I feel like I don't know if he's in custody or not, or who's to say he's not in custody currently. So very interesting. This doctor is trying to inquire about custody of the patient in regards to allowing the police officer to interact with them, which the doctor in Alexee Trevizo's case didn't have any clarification on custody, didn't need any clarification on custody, trying to relay a pertinent medical fact to a patient that now has to somewhat involve the police officers from here on out because of the stakes of the situation. And so this doctor is actually considering custody, wondering about custody, and trying to keep the officer out to convince this person to do stuff. So, this is a fine line that these doctors are having to dance. And now if you compare what's been done in the Alexee Trevizo case, it seems very clean cut, very professional, and there was a decided moment of detention for Alexee. And this seems a lot more back and forth. The police officer may or may not be trying to get more information than they're legally allowed. But as we'll get to the end of this, that's not what the Court of Appeals decide. They decide that there was no infringement on the rights of this defendant based on this interaction. And so if this interaction is so intertwined, then really, how can we say that something went wrong in the Trevizo case? So let's continue. Smith, the police officer, affirms he's detained. Yeah. Doctor, oh, he's detained? Okay. Smith, he's not free to leave. Doctor, great. The doctor then returned to Hudson's room. A few minutes later, medical staff's voices became more forceful. Their commands grew into a chorus. Spit it out. Those drugs are going to go into you. Stop chewing on it. And nobody cares about a little drug. Spit it out before you get yourself hurt. After the chorus faded without success, the doctors again implored Hudson to spit out the item, noting that Hudson was detained. Finally, after 20 minutes of coaxing, admonishing, and commanding, Hudson spit out the object. The object was not drugs, but rather a device used to convert a Glock firearm into an automatic weapon. When the doctor exited Hudson's room once more, Smith asked if he could speak with Hudson and conduct the gunshot residue kit. The doctor stated that he wanted to conduct x-rays of Hudson first because it was the, quote, medically right thing to do. Smith again stated, no problem, sir. We'll work around you. While Hudson was x-rayed, a staff member asked Smith whether Hudson would be charged for possessing the Glock component. Smith responded, you guys have acted as an agent for us, so I don't know that I can charge him with it. Whoa. Okay, so I just read the synopsis of this. I just found this as relevant case law. I've not read this whole thing. Wow. Okay, we need to address this. The cop straight up says, you have acted as an agent for us, so I don't know that I can charge him with it. This was denied that the doctors acted as agents of the law by the Court of Appeals. And the literal officer said that the doctor was acting as an agent. Right up here, the doctors implored Hudson to spit out the item, noting he was detained. So the hospital staff used the legal status to try and convince the patient for medical needs, right? And this guy straight admits it. Are we feeling confident for Team Trevizo that they're going to win on an appeal when none of this happened? I don't know. I'd be pretty scared if I were them. And remember, this is from late 2023, end of year 2023. This is fresh and new, possibly, very, very possibly, something that the New Mexico Supreme Court will be reviewing, possibly something that they reference. Who knows? But this is so bad for Team Trevizo's defense. We can continue. Smith explained that police officers cannot ask private actors to do things that they cannot do themselves, but then noted, this is a little bit different because you guys have every right to ask him to do that. Surprised by Smith's comments, a staff member responded, we just really thought it was drugs, so we wanted him to spit it out. Procedural history. Under federal law, the Glock component that Hudson had in his mouth constitutes a machine gun, and that's what he was charged with, possession of a machine gun. Let's see here. Hudson moved to suppress the Glock component, arguing that the medical staff acted as government agents when they directed him to spit it out, thereby conducting a warrantless search in violation of the Fourth Amendment. After a hearing, the district court held that medical staff did not act as government agents. The court found that medical staff acted with the purpose of providing medical treatment to Hudson, and that Smith neither induced nor encouraged medical staff to act. Let's see here again. The court found that medical staff acted with the purpose of providing medical treatment to Hudson, and that Smith neither induced nor encouraged medical staff to act. There is absolutely zero evidence that the police induced or encouraged the doctor to say what they said in the room to Alexee Trevizo. There was no inducement and no agency. I can't get there. I've never gotten there. And so to see this in plain language here in a case where maybe one could say that using the detainment argument that the medical staff did kind of threaten the patient in a way that would be seen more as agency than medically necessary, even though it was medically necessary as well. And so I think that there's more argument to be made here. Not that, this is, I don't disagree with the decision, but there's more argument here than in the Alexee Trevizo case. And this was rejected. So let's continue. The court alternatively held that even if medical staff had acted as government agents, the emergency aid exception to the warrant requirement applied. Oh, snap. Okay, so Alexee Trevizo was in life-threatening condition because of not knowing about the placenta and the, anything that could be remaining that's causing hemorrhaging and not allowing everything to close up after giving birth properly. And that was life-threatening. So I wonder, hey, even though this wasn't formally argued by the state in New Mexico, if there is some sort of emergency aid exception that we may be seeing come listed in the Supreme Court's decision. The court therefore found that suppression was not warranted and denied Hudson's motion. This is just explaining that he reserved the right to, appeal this motion to suppress that was rejected despite having a guilty plea. Now let's go over what the Court of Appeals actually said. They said, discussion, Hudson's only argument on appeal is that the district court erred in denying his motion to suppress the Glock component. The thrust of his argument is that the medical staff acted as government agents when they ordered him to spit out the component, and thus their actions amounted to a warrantless search in violation of the Fourth Amendment. We review district court's decision on motion to suppress under a mixed standard of review. We review the district court's legal conclusions and conclusions on mixed questions of law and fact de novo, meaning anew. The district court's factual findings are reviewed for clear error. A factual finding is clearly erroneous only if, after considering all the evidence, we cannot avoid or ignore a definite and firm conviction that a mistake has been made. Just as a quick aside, we do have findings of facts and conclusions that came from the district court judge in the Alexee Trevizo case. And in my personal opinion, I do believe that they will find them clearly erroneous. But yeah, let's continue. The Fourth Amendment guarantees the right of people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. The amendment protects citizens against unreasonable searches and seizures by the government. It does not apply to searches and seizures conducted by private individuals, no matter how unreasonable. Do we think the one in Alexee Trevizo was unreasonable? What the doctor did? No. So even if it was crazy, unreasonable, unfathomable, they're saying it would still not amount to this agency issue. But the government may not simply enlist private individuals to do its bidding in an attempt to avoid its Fourth Amendment obligations. The government may not do through a private individual that which it is otherwise forbidden to do. Fourth Amendment protections therefore apply to a search or seizure conducted by an ostensibly private individual when the individual acts as an instrument or agent of the government. This gets very interesting in the Alexee Trevizo case because is a mandatory reporter an instrument or agent of the government simply by being a mandatory reporter? And if a court actually decided that they were, and that things that a mandatory reporter found out were in violation of the Fourth Amendment, then all mandatory reporting would be called into question. So despite that interesting little caveat that one could try to argue that, well, a mandatory reporter is already an instrument or agent of the government, which the defense at oral argument basically did try to do by trying to argue that baby Alex should have been reported as a suspicious death, not a child abuse report, because that would ultimately help Team Trevizo in the argument that the statement should be privileged. They would no longer be about a mandatory reporting issue, just a random suspicious death. But the implications of that argument being agreed with by the Supreme Court just go way past this case for baby Alex. And so do I think that that will be successful and a successful argument on the little close tangential thing that you can say, well, maybe they were an instrument or agent? No, I do not. We can continue. The defendant bears the burden of proving that a private individual acted as an instrument or agent of the government in conducting a search. To meet this burden, a defendant must prove some exercise of governmental power over the private entity, such that the private entity may be said to have acted on behalf of the government rather than for its own private purposes. There is no, quote, rigid formula for making such a determination. Rather, a court should conduct the analysis on a case-by-case basis in light of all the circumstances. We have nevertheless identified two critical factors to assist courts in the analysis. One, whether the government knew of and acquiesced the intrusive conduct, and two, whether the private party's conduct was done with the purpose of assisting law enforcement or to further its own ends. Other useful criteria are whether the private actor acted at the request of the government and whether the government offered the private actor a reward, neither of which happened. The district court found that each of these factors pointed to the non-existence of any agency relationship. We agree. Hudson zeroes in on the acquiesce language of the first factor, arguing that Smith clearly knew of and acquiesced in medical staff search because Smith maintained a constant presence both inside and outside his hospital room and stood idly by while staff directed Hudson to spit out the item. Similar argument about where the police officer was in conjunction to the room that we have in the Alexee Trevizo case. Knowledge and inaction alone, however, are insufficient to establish an agency relationship. Read this again. Knowledge and inaction alone, however, are insufficient to establish an agency relationship. What did the police have in the Alexee Trevizo case? Knowledge. And what did they do? Nothing. They went into the room and the doctor explained that they found the baby and begged Alexee to accept the life-saving treatment, to which Alexee's response was, yeah, fine, whatever. That was her response to the doctor trying to save her life. So with that, yes, the police had knowledge, and that was a huge argument at oral arguments. If you guys have watched oral argument, you will have seen that they pounded on the idea that the police knew that Alexee had potentially committed a crime when they walked in that hospital room.
But that might be different if they were just going room to room saying we'd like everybody's name and information. But here they had this body of knowledge before they walk in the room, and that's what troubles me in this case.
Because the doctor told the police before she went in the room, I need to go tell her about what her condition is.
But it's not about what was known to her. It's about what was known to the police when they said, yes, sure, we will go into the room and have the conversation with you, because that's their yes to the statement. So it's not about what she knows. It's about what the police know and what their motivation was to go in the room and have a conversation with Ms. Trevizo.
What does this clearly say? Knowledge and inaction alone, however, are insufficient to establish an agency relationship. The mere fact that police witness a private party search does not transform the private party into a governmental agent. Mere knowledge of an other's independent action does not produce vicarious responsibility absent some manifestation of consent and the ability to control. Rather, there must be both governmental knowledge of the action or of the policy or practice of performing such actions, combined with, quote, some exercise of governmental power over the authority, some manifestation of consent, and the ability to control. There must be some evidence of government participation in or affirmative encouragement of the private search before a court will hold it unconstitutional. Passive acceptance by the government is not enough. Emphasizing the few short interactions between Smith and medical staff, Hudson insists that Smith did exercise such control here by encouraging the search and inducing medical staff to act. He pointed to a few isolated instances in which Smith was involved in nearly a 20-minute event, including that the doctor asked Smith for help in convincing Hudson to spit out the item, that medical staff mentioned the presence of police in attempting to convince Hudson, and that Smith made his presence known to staff and even on occasion directed Hudson himself to spit out the then unidentified item. But as the district court correctly observed, we cannot view these facts in isolation. But as the district court correctly observed, cannot view these facts in isolation, which I feel like Team Trevizo kind of wants everyone to look at that night in little isolated facts that have been glossed over, but that's just my opinion. Instructing that review of whether an agency relationship exists should be on a case-by-case basis and in light of all the circumstances. While we agree that Smith had some degree of interaction with medical staff, The district court did not clearly err in discounting this interaction and finding, based on all the circumstances presented here, that Smith did not attempt to induce medical staff to act or otherwise manifest any ability to control medical staff's action. Hudson, for example, pulls out of context that after an extended period of attempting to convince Hudson to spit out the object, the doctor asked Smith if he had any ideas on how to convince Hudson. The doctor also asked Smith if Hudson was detained, and when Smith responded that he was, the doctor leveraged that information in his attempts to convince Hudson to spit out the item, which is what I thought was the best argument. But in the same conversation, Smith disclaimed any interest in charging Hudson for drugs. Viewed in context, Smith's statements that Hudson was detained does not clearly evince an intent to induce action, as Hudson contends. Smith was simply answering the doctor's questions and did not direct the doctor to act in any particular way. Indeed, it would be difficult to find that Smith intended to induce the doctor or medical staff to obtain the suspected drugs from Hudson's mouth, where Smith affirmatively disclaimed any evidentiary interest in them. Now, hold on. I just need to argue this a little bit, because as I'm reading this, like my little paralegal brain's going off, and I'm like, hold up. No, I mean, this person has a better argument than Alexee Trevizo, and it got rejected. So first and foremost, let's just put that on the table, because I do think that the doctor used leverage of this guy being detained to try and get him to spit it out. And the doctor didn't do that until after learning he was detained. And it doesn't matter if a cop says, go ahead and spit those drugs out, I won't charge you for them. Are you going to trust that cop? I mean, I'm not advising you, but I probably wouldn't spit the drugs out in front of the cop who says, don't worry, I won't charge you. No, this dummy kept, something on them that the officer did end up charging them with, even though they didn't have the intent to charge them with drugs. They did charge them with what came out of their mouth, right? And in Alexee Trevizo's case, all we have is that the doctor had the police there within 10 minutes, told them, I haven't gotten a chance to talk to her yet. I need to tell her what's going on and tell her I got her a transfer. Would one of you be willing to be present for that conversation? All the doctor probably wanted was a third party and that video recorder in there for what the doctor said next, because now a bunch of liability is on the hospital. And would you look at that? There's been a wrongful death lawsuit and now a civil lawsuit again filed against the doctor and the hospital from, Team Trevizo. So it's beginning to look pretty smart that the doctor wanted the police officers there, in my mind, and not as an agent of law enforcement. But if we're assessing this argument and saying just believe the cop that they won't charge you with what you spit out of your mouth, doesn't seem like the one you should believe, because you still got charged with what you spit out of your mouth. And even though the hospital staff were saying, hey, you're detained, spit it out now, and use the force of the police, in my opinion, to try and get him to spit it out, it still wasn't considered an unlawful search and seizure. So pretty interesting, because I feel like that's way past what happened in the Alexee Trevizo case. Let's just continue here. Absent any manifestation of consent and the ability to control these facts, do not transform the medical staff's action into a government search, holding that medical staff do not act as government agents where they acted on their own initiative to, quote, search the defendant, but received some assistance from law enforcement officers in executing the search. Hudson's reliance on other small interactions between Smith and medical staff are likewise undermined by the rest of the record. As the district court found, medical staff were uninterested in Smith's presence and even asked Smith to leave Hudson's room. So Smith stood outside the room for most of the events in question. When Smith attempted to interject in the attempts to get Hudson to spit out the item, medical staff ignored his first interjection, and then the doctor shut the curtain in response to his second. Smith repeatedly assured medical staff that he would stay out of the way, and his only request to the doctor during the entirety of the encounter was that Hudson's hands not be washed. And even then, rather than simply complying, the doctor stated that washing hands was not something he normally did in treating patients' gunshot wounds. From all this, the district court could certainly conclude that Smith did not exercise any control over the search, and medical staff were, in fact, calling the shots. Observing that the court has never found agency where, quote, government participation was, quote, minimal, as an officer briefly inspecting the exterior of a package and then watching a private individual open the box and inspect its contents. Okay, so the second factor is actually extremely interesting when it comes to the Alexee Trevizo case as well when we're doing this comparison, because it says here, turning to the second factor, Hudson also asserts that the district court erred in finding that medical staff acted with the purpose of providing medical care to Hudson and not as to assist law enforcement. We disagree. This is interesting to me because we've long said here on this channel that if you listen to what the doctor actually said in the Alexee Trevizo case, not based on emotion, not based on someone's thoughts as to what the doctor should or shouldn't do, the actual statements that the doctor makes are to inform the patient that they have made a new medical discovery that is relevant to the patient, and then ask them to agree to the life-saving transfer that is necessary due to the doctor getting this new information. The information being that Alexee Trevizo isn't suffering a miscarriage. She isn't suffering some weird issue with any kind of pregnancy. It's not a kidney stone. It's none of this. It is postpartum hemorrhaging, and the doctor does not know about the placenta. So the purpose of the conversation that happened was so that medical staff could continue to provide medical care to Alexee Trevizo and properly provide medical care to Alexee Trevizo. So let's just see what else this court is saying about medical care and agency. As an initial matter, we emphasize that a private individual's independent intent to assist law enforcement alone cannot, quote, transform a private action into a public action, end quote, stating that both sides must agree to the formation of an agency relationship, end quote. Something more than approval is necessary, noting that two critical factors are not independently sufficient to convert a private search into a governmental search. There also must be some governmental manifestation of consent and the ability to control, because we agree with the district court that Hudson failed to show any such manifestation here. It is of no moment whether medical staff's purpose, even if sole or paramount, was to assist law enforcement. Even if there had been some manifestation of consent and control here, we see no clear error in the district court's finding that the medical staff did not act with the purpose of assisting law enforcement. Reviewing for clear error in the district court's finding that private individuals did not act with purpose to assist law enforcement. As the district court found, medical staff repeatedly expressed concern for Hudson's safety when directing him to spit out the item and emphasized the health risks posed by them if it stayed in his mouth. They also directed Hudson to spit out the item before Smith even knew that Hudson had anything in his mouth. And when Smith stated to medical staff that they had acted as his agents, they expressed surprise because they simply wanted Hudson to spit out the suspected drugs. Taken as a whole, these facts supported a finding that medical staff acted with the purpose of providing medical treatment. Hudson contends that other evidence in the record belies any such finding. Specifically, he argues that medical staff could not have acted with a medical purpose because it was not medically necessary for him to spit out the item to obtain treatment for his, quote, flesh wound. He further argues that once he refused the, quote, medical treatment, i.e. spitting out the suspected drugs, medical staff's purpose in directing him to spit out became purely to collect evidence because he had invoked his right to refuse medical treatment, thereby relieving staff of their obligation to provide such treatment. Hudson misunderstands the relevant inquiry. It is not whether medical staff were correct about the medical necessity of their conduct, but simply whether they acted pursuant to a legitimate independent medical purpose as opposed to a desire to assist law enforcement. Thus, even if it was not medically necessary for Hudson to spit out the item, or if such a treatment was unwarranted in light of Hudson's invocation of his right to refuse medical treatment, that would not somehow nullify their subjective purpose to render medical treatment. Under normal circumstances, of course, medical staff should have had their patient's consent, but their judgment remained a medical one. It was not nullified by the defendant's refusal to give permission. Once the court is satisfied that a private entity has conducted a search for its own private reasons and not as an instrument or agent of the government, the specific reason for the search no longer matters. In any event, we are unpersuaded that it was medically unnecessary for Hudson to spit out the item. Medical staff operated under the assumption that he had drugs in his mouth and repeatedly indicated that the suspected drugs could cause him to overdose if the container they were in ruptured. Although this assumption was ultimately mistaken, it does not undermine the fact that staff viewed it medically necessary for Hudson to spit out the item to prevent a second medical emergency from eclipsing the first. They also expressed concern that the item could cause Hudson to choke or occlude his throat if he needed to be intubated, further indicating that their concerns were not merely speculative, but were related to their treatment of his, quote, flesh wound. Hudson again lifts isolated statements out of context in an attempt to argue that staff intended to collect evidence rather than provide medical assistance. He points to the fact that the doctor mentioned that the item was, quote, evidence when asking Smith for help in getting Hudson to spit out the item. When viewed in context, however, the doctor's statement is much more innocuous. The same sentence, the doctor expressed his concern that Hudson would swallow it and, quote, end up sick. The district court's conclusion that this ambiguous statement, at best, could be construed as a request for help in accomplishing medical staff's medical purpose, and that the reference to, quote, evidence and a, quote, crime scene was because Hudson had been shot, was not clearly erroneous. Now, as you've heard me say, I don't agree with what this person did. I don't agree with this situation, but I do think that this Hudson defendant actually has a little bit more of an argument than Trevizo does. And for that, we must look at what they literally just said, that the ambiguous statement at best could be construed as a request for help in accomplishing medical staff's medical purpose, and that the reference to evidence in a crime scene was because he had been shot was clearly not erroneous. And to me, that immediately reminds me of the statement that the doctor made asking if the police want to be present for the conversation. And their purpose, the medical staff's purpose in that conversation, was not to pull out a confession from a defendant, but was to further their own medical needs for that patient, right? And so with this conclusion, they're saying, really, even though this person used evidence in crime scene and knew this person was detained and said, spit this evidence out as a doctor, they're still not an agent of law enforcement, right? So it's still begs the question for me, how in the world in the Alexee Trevizo case did we get to the point where the doctor magically turned into a police officer, as we have said for over a year now? I still don't get it, but we can continue on here. Noting that a private party is not transformed into a government agent when they have both an intent to assist law enforcement and a legitimate independent motivation for engaging in the challenged conduct, quotation omitted. In sum, we conclude that the district court did not clearly err in finding that Smith did not induce medical staff to act, and that the medical staff acted with the primary purpose of providing medical care. Viewed together, these factors lead us to conclude medical staff did not act as government agents in directing Hudson to spit out the item. That Smith afterwards indicated to medical staff that he believed they acted as his agents does not alter our conclusion here. Smith, after the fact, subjective speculation as to the existence of an agency relationship, a legal conclusion, does not override the effect of the underlying facts in this case, noting that the ultimate question, whether a private person is actually a government agent, is, quote, a question that requires the application of a legal concept to facts. Something, if I may personally add, was seriously lacking in the district judge's opinion that suppressed the evidence in the Alexee Trevizo case. And those facts, when looked at objectively and in their totality, do not support the existence of an agency relationship. Conclusion: Hudson has failed to sustain his burden of proving the existence of an agency relationship. Accordingly, the Fourth Amendment does not apply to the medical staff's actions, and the district court properly denied Hudson's motions to suppress on that basis. The judgment of the district court is affirmed. So bringing this back to the civil lawsuit that Alexee Trevizo has filed against Artesia General Hospital and City of Artesia, but really the police, and them having to be connected because the doctor is magically a police officer, hopefully this, appeals decision to reject an agency argument sheds a little light on what we may hope to see come from the Supreme Court, which will ultimately guide what will come in the civil cases that have been filed, both the wrongful death lawsuit and now the civil rights lawsuit. Both of those really hinge on what the Supreme Court decides, because if the Supreme Court were to come back and say that the hospital and the police messed up severely, then not only would the criminal case be impacted, but both of the civil cases could be seriously impacted as well and would tip in the favor of Team Trevizo. But if the Supreme Court comes back and does not rule that anyone violated any of Alexee's rights and that the evidence is not only allowed to be used in the trial against Alexee Trevizo, but that there is no intent or wrongdoing or agency behind any of the investigation on behalf of the police or the doctor's actions that night, then both of the civil lawsuits are seriously impacted and tip even more in favor of the police and the hospital rather than Team Trevizo. Because even if, let's say, the wrongful death lawsuit makes its way to some sort of a trial, whether it's by judge or by jury, and they believe that there's enough argument to be, taking this all the way on the little bit of time before, acknowledging the positive pregnancy test to Alexee and the minuscule amount of morphine that was given, they will still be held to a standard of contributory negligence, which means whoever the fact finder is in that case will have to weigh whether letting Alexee go to the bathroom alone while knowing she could be pregnant but not knowing how far along she was, and giving her some morphine for her back pain at the amount and rate that she was given it is more likely to have caused the death of baby Alex than him being placed in a bag. And that is where the percentage of fault is going to actually get parsed out. And let's say someone doesn't like that the hospital gave some medications to Alexee or let her go to the bathroom. It still could fall to the 0.01% blame on the hospital and 99.99% blame on Alexee, right? And so that's where the civil case is going to face serious issues when it comes to wrongful death. And a civil rights case is going to face some serious issues because it does not appear that any of Alexee Trevizo's actual rights were violated when the police show up to the hospital and how they show up to the hospital, as we can see by going through that appeals decision and it very clearly laying out the disregard for the agency argument made by that defendant. They did not care. And you may agree or disagree, but I actually think that that defendant had a little bit better of an argument than Team Trevizo does when it comes to turning the doctor into the police officers. In Alexee Trevizo's case, there is mandatory reporting laws that the doctor and hospital have to abide by, and that does not automatically turn someone into an agent. It would, in fact, undermine the entire purpose of mandatory reporting if it turned them into an agent of the police, because then statements would potentially be needing Miranda, evidence would be getting suppressed when the people who come in contact the most and, are the best people we can have on the front lines trying to protect children, if they were to get information or statements, it would be seen as police officers getting statements and would be under the same scrutiny. There's a reason we have a middle line for mandatory reporters, which they're not quite private citizens, but they're not quite state agents. And having it go either other direction causes issues for, children, because number one, doctors are the people who come in contact with abused children the most when it comes to sustaining injury. They have the best opportunity to be helping an injured child who may be injured due to abuse. Teachers have the best ability to, come in contact with abused children and be able to report it because of the frequency and the amount of children that they are around on a daily basis. They can notice something off with a child that may not even be in one of their classes or in their classroom, but they notice something. And so just the nature of being around children in the way teachers are, the nature of being a doctor allows for the ability for these statements to be made in times of need or in notice from people who have the ability to do something about it. I know I kind of drone on and on about this, but it's very important because realistically, if the Supreme Court were to accept the defense's arguments, they are undermining the entire mandatory reporting system that New Mexico has, and it would gravely impact the safety of children because we can all already agree that the system is not perfect. Children fall through the cracks. The foster care system is not perfect. It is not ideal. But the last thing we want to do is make it worse or harder or make it dangerous for these mandatory reporters or people who come in contact with children to try and help in these situations. The evidence will be suppressed because of their nature of their job. It just doesn't make sense. And there's a reason our society is set up the way it is in regards to this. And there's a reason why the defense is trying to jump through hoops in the Alexee Trevizo case and try and turn it into a suspicious death argument rather than a report of child abuse argument, because it always waives privilege. It doesn't make sense if you take it even to a further step. One of the cases that was heavily referenced by the state and the defense in their briefs for the Alexee Trevizo case is a case where they ultimately redefined what the privilege statute means. And it was because there was a man who admitted in his therapy sessions to abusing a child. And it obviously spawned an investigation and charges for this person. And they were trying to fight it based on the privilege that they thought they should have on how the statute was written regarding privilege at the time. And obviously it undermines the entire reporting statute if, say, the person who admits to abusing a child makes that admission in a very general sense and then goes into detail about who the victim may be, where it happened, things that would help a police officer in an investigation about this abuse, then kind of what Team Trevizo is asking for is for reports to end with just the initial bit of information, and then everything past that is safe. So if a predator did say that they harmed a child to a therapist, boom, they want it to end there. Any extra information they get would be not fair game. It would now be privileged. And I just don't think that the logic in that situation makes sense. So I don't think that we can apply the logic in that situation to Team Trevizo with baby Alex being found in the hospital, where, the hospital can say that they found a baby, but they can't say anything else about it. It's just a suspicious body in a closet is kind of the argument it came down to at oral arguments. Say you found a body in a closet, and it's like, yeah, but say that you knew that the patient you're treating just killed that body and put that body in the closet. Now put that into the equation. That's where it gets a little different. Now say that body that's in a closet is a protected class already decided by our laws in America and in New Mexico because of their age. They're a minor. That would be a potential child abuse, which is how the exact statute that Alexee Trevizo is charged with is written. It is child abuse resulting in death. Also murder one. But that's the original language of what Alexee was charged with, right? And so all of this would undermine the foundation of the attempts to keep children safe in New Mexico. And I just cannot fathom them making a decision that would impact all these other cases on the facts that they have in the Alexee Trevizo case. Again, the off-the-wall argument sort of that we've had, but was eventually put into a brief. So maybe it wasn't that off-the-wall of an argument in the long run, but we've been saying that the privilege in New Mexico hinges on the attempt to be getting treatment, right? And it doesn't explicitly say that you have to be honest with your providers, but it implies that you're trying to actually get accurate treatment. And in Alexee's case, I think the best argument we have is that she clearly wasn't trying to get accurate treatment, at least at the point of being in and exiting from the bathroom. I think that we can clearly establish that that was not attempting to get medical assistance, because otherwise Alexee Trevizo would have told someone what happened. She would have told the doctor, not only when it happened, not 10 minutes later, not when she exited the bathroom, but when the doctor is sitting there dumbfounded, doing a vaginal exam, being like, where's all this blood coming from? What's going on with this? Sitting there and still not saying anything. I think that's what undermines the privilege, right? And so if this really were the case with the facts that could impact future child abuse reporting, I would be more nervous. It's not nerves that I have for it coming back. The logic is sound that we should get all this evidence back, which makes this civil lawsuit pretty null and void. What I worry about is that it won't be logical, that it won't be sensible, that maybe it'll be some sort of emotional reaction. And the likelihood of that is low, but you have to remain prepared that anything can happen when the Supreme Court is making a decision. But do we really think, after reading the appeals decision we just read, after knowing the stakes that are in play for this decision when it comes to the future justice of children in New Mexico, and when you watch oral argument with a very close eye and listen very carefully for some of the things that were said by the justices in regard to the defense, can we have a little bit of hope and belief that when this decision comes back, it will be in favor of the state and in favor of justice for baby Alex? I think we can keep that hope alive, especially in this time of year. As we're seeing these lawsuits fly around, we're seeing Alexee get sued right before Christmas for debt. Now Alexee suing the police and the hospital. We also have the 3-year memorial of baby Alex's death coming up on the 27th of this month. And we are still waiting for this decision from the Supreme Court. Now, they did just come out with a decision that happened to have their oral arguments the day after Alexee Trevizo did. And it also happened to have a judge who was sitting in, listed in 2 spots for the judges. That means that some other judges are assisting, whether it's due to time constraints, whether it's due to just their general ability to assist, whether it's due to a case load that is too high. It does not mean that there will be any sitting justices on the decision for the Alexee Trevizo case. In fact, I put that at a very low likelihood due to the fact that this is a very big, a lot of eyes on this case, a lot of pressure put on the court from the side of the defense, in my opinion, on this case. And I don't think that they will have a sit-in justice on that decision. But the fact that they are having sit-in justices can indicate that time is of the essence for them. And this is likely one that is taking up a lot of their time, because not only are they able to do research based on the case law that has been presented to them in the arguments from the defense and the state, but they are also able to outsource into decisions like we just read, like Hudson and possibly, I believe it was Crowley is one that is referenced in Hudson. And so I do believe that we may be seeing this delay because there is a lot of reasoning behind why this evidence should come back. There was absolutely zero case law that came from the judge who suppressed everything, which essentially means these justices are having to do everything from scratch and make this decision. And they are being asked to balance precedent. So with that, I do feel it that it's coming soon. It's only a stone's throw away, but it is seriously going to impact these civil cases that Team Trevizo has put out. And realistically, the biggest question we'll have after this is Team Trevizo going to continue to try and take this all the way? Are they going to take this to trial? Or once all this evidence is back in, are they going to be realistic and realize that, they're cooked? Are they going to be realistic and try and attempt some sort of plea? I can't imagine taking this all the way to trial with these facts. If I was the defendant in this case, I mean, I'd be trying to figure out something else, right? Because at least in New Mexico, murder two doesn't have a mandatory minimum unless that's changed since the last time I verified that. And I mean, maybe, just maybe, Alexee could get away with the deal. It's possible that they're not willing to offer a deal and there is no negotiating that's coming to happen. But this could be the final, the final straw for Team Trevizo to begin a negotiation in the first place. I mean, really, they've had all the chips, this entire time. They've not needed to negotiate. But if all their chips are taken away from them, it might be the reality check that, they need as quote unquote a defense team looking at a murder trial, right? Like in its entirety, it's technically only up to Alexee what they move forward with. But even if 50% of this evidence comes back, I think they should be scared. Anything that's creeping up above 50% of the evidence is looking more and more like a sure thing for a guilty verdict. And that's based on not just what Alexee did. That's pretty clear. But the intent and the premeditation is going to be very easily implied, in my opinion, based on all of Rosa's statements and how Rosa reacted that night. It's going to be hard for Rosa to convince a jury that when she said, Alexee, I just asked you to tell me the truth, that it was after Alexee went to the bathroom and not before, indicating that there was no knowledge before Alexee went to the bathroom of her pregnancy, rather after. But the more Rosa tries to deny that her statements could indicate, the guilt of Alexee, the more it's going to look like she is evasive, and they probably do. If anyone's ever seen an evasive witness on the stand, or maybe even one who is trying to be honest about a fact that really just doesn't look good for them and they're already not going to be believed, you can see the kind of squirming that comes from that. And in this case, it's going to be very, very hard for Rosa to explain away her statements on the stand and not look like she's trying to shelter Alexee. If you couple Rosa saying, I just asked you to tell me the truth, and her showing up to the bathroom within 40 seconds of Alexee closing the door with only the supposed knowledge of Alexee having back pain and constipation, which is common for Alexee, it looks like the urgency to follow her to the bathroom is a little off kilter. Why would she be following someone who has this kind of issue all the time unless something else was going on? Do we have another indicator that Rosa might have thought something was going on to push her to go to the bathroom that quickly after Alexee? Oh yeah, her statement saying, I just asked you to tell me the truth. All of that together makes it look like Alexee could have been being asked by Rosa before she went to the bathroom about the possibility of being pregnant. And so if all these statements come back in, it is a bad day for Team Trevizo. Now, something interesting when it comes to all of this evidence, all of everything we've been discussing, essentially, there is a criminal defense attorney who has a YouTube channel, and they make videos about the more viral big stories that happen. Now, when the Alexee Trevizo case first was going viral, this channel, Bruce Rivers, criminal lawyer, reacted to the body cam footage and the arrest of Alexee Trevizo. Now, Bruce Rivers, being a criminal defense attorney, properly points out a couple things in this video and then doesn't freak out about one thing that I think should be very interesting in telling to us as we are waiting on pins and needles for this decision from the Supreme Court. Now, just to point out that essentially he is probably a pretty good defense attorney. He immediately clocks the two lines of defense for Team Trevizo, which they are still going with one of them to this day. The other one, they unfortunately for them don't have the ability to make that argument. But Bruce Rivers does say, their argument is that the baby was never alive. And then at another point, he's unaware that the medical staff did not try to resuscitate baby Alex at all. But he brings up how that could possibly cause some reasonable doubt, but the autopsy will be a battle of science. So He's basically clocked exactly what's happened in this case thus far, as far as it's going to be a battle of science based on the autopsy, and they're still trying to claim that baby Alex was a stillborn. There just happened to be no medical intervention. But when reviewing the hospital footage, the body cam, Bruce Rivers watches the moment where the doctor tells police officers that she needs to tell Alexee that she needs to be transferred and hasn't talked to her yet. Would one of them be present for that conversation? And they begin going into the room. There is not a single reaction from Bruce Rivers, criminal lawyer, who does point out that Alexee should be Mirandized whenever she's being detained. He does point out other things that he thinks could be beneficial for the defense. Like I said, possible medical intervention, other things. He's not trying to stick up for Alexee. At one point, he even throws some shade at Alexee and is like, how was prom? Because I think that kind of disturbed him, even though he gave understanding to the teenager mind of kind of like out of sight, out of mind. They don't have that permanence, but I think it still obviously disturbed him that she just did this and went to prom and was like, kept my life the same. So with that, the fact that Bruce Rivers, criminal lawyer, did not react when the doctor invited the police officers into the room, when Alexee made all these admissions in front of the police, that leads me to believe that he doesn't think that the doctors had any agency as far as the police, and that argument is going to be very weak. Another interesting thing that Bruce Rivers said is after Alexee Trevizo is detained by the officer, not Mirandized because they do not plan to interrogate her, Rosa begins to ask Alexee questions in the presence of one of the officers while he's calling in the IDs. Now, the officer does stop Rosa from questioning Alexee, but part of it is caught on camera before he's able to stop her. And I've always claimed it was Rosa's interrogation of Alexee because she straight up did interrogate Alexee, in my opinion. Now, Bruce Rivers stops the video right there and says that this is a conversation between a witness and a suspect, not the police. And he just straight up says,
not privileged. So, and the cop is right there. So even if she would have invoked Miranda, a conversation between the two of them would be fair game.
So I hope that this gives us a little bit of hope as we are waiting and continuing on and keeping up the hope on the road to justice for baby Alex. And please do know that as we have had for the last 2 years, we will be having a memorial video for baby Alex on January 27th. It will be in the same fashion that I've done before, with the 15 minutes of silence to represent the time baby Alex was kept in that bag at the very end of the video. But for now, continue to keep up the hope on the fight for justice for baby Alex. We will continue to go through all these lawsuits that are making their way as they start to heat up. And we will obviously go through the Supreme Court decision with a fine-tooth comb the minute it's returned. Thank you so much if you made it this far in this video. If you have any comments, questions, or concerns, please leave them down below and I'll get back to you as soon as possible. And I do genuinely enjoy the conversation. If you're interested in following cases like the Alexee Trevizo case to trial, please subscribe, as I'll be covering it all along the way with a legal focus. It's your Friday. I'll see you in the next video. Goodbye.